And thank you to everyone for coming today. Also, thank you to our three panelists for taking their time out, their busy schedules to come join us today. As you know, we're going to be discussing NIL. We're not going to spend a lot of time getting into the background. We're going to use all their varying perspectives to get a good feel for this. So I guess my first question would be addressed to Jeremy. Wait, scratch everything that I just said. Why don't you all go through and say your names and what you do, your roles, and a little bit of your interest in NILs. You can start, Jayma.
I'm Jayma Meyer. I teach sports law and public policy spring semester at IU. Otherwise, I'm an antitrust, now Title IX litigator in New York City at a large global law firm. But I've become a gigantic Title IX advocate over the last 8 to 10 years, and also been very interested in the intersection of sports and antitrust. So if you want to take a class on sports law and public policy, please join us in the spring.
I'm Tyler Harris. I'm the executive director of Hoosiers for Good and Hoosiers Connect, two NIL organizations that are intended to benefit IU athletes. Prior to this, I was the head of the compliance office in the athletic department at IU.
My name is Jeremy Gray. I'm a senior associate athletic director at Indiana. I'm a member of our NIL task force. I oversee communications, digital, social media, broadcasting for the athletic department. But as it relates to NIL, specifically, I help with student athlete brand building, the marketing of our NIL efforts, and student athlete education, less so on the policy side. I teach sports broadcasting 333 in the media school. I don't know if it's relevant for any of you, but if you want to learn how to make more exciting closing arguments, feel free to take my class in the spring.
Thank you for that. So now my first question is directed to Jeremy. Just broadly, if I'm an IU athlete coming to you about NIL, what does that look like?
It's a terrific question. And I think one thing that Indiana has done in this space that maybe is no longer unique, but was unique in the early stages of the post-July 2021 world is I think IU takes a holistic approach. Actually, the law school is a part of that holistic approach. Student athletes in all 24 of our sports have been able to take advantage of name, image, and likeness deals. Two, we were, I think, the first school in the country to utilize Open Doors, which is a content delivery platform that enables student athletes to build their social media followings to become more likely marketable influencers. And we help them with social media best practices, things like that. We've also engaged with the media school on social media best practices to help teach our student athletes ways to increase their following and to be responsible actors in that space. We have made a partnership with the law school to help review contracts and give legal advice to student athletes who are engaging in agreements with outside parties for their name, image, and likeness. And I think business education is really, really important. I think there's been a fixation upon the part of a lot of athletic departments and in college sports on how much of the student athletes getting paid, but not nearly enough consideration on letting them know what actually April means to them, to make sure that they're managing their finances well. If they're running camps and clinics, understanding where tax write-offs might be and things that they have to consider. What in perpetuity means in a contract. So to make sure they're not signing deals that seem really good in the short term, but when they make the WNBA or Major League Baseball, preclude them from getting larger deals that are just part of the process of being with that. And then I think we're very lucky, and Tyler can take it from here, in that we're an athletic department that has 3 collectives that are actively supporting student athletes at IU. Hoosiers for Good, Hoosiers Connect, and Hoosiers Hysterics. They all do different things. But our student athletes have been able to find plenty of opportunities there. And I think an important thing is to understand scale. So a student athlete like Sydney Parrish, the women's basketball player, Mackenzie Holmes, Trace Jackson Davis, they're making a considerable amount of money off of their name, image, and likeness. And that is really important. And I think it's an idea whose time is long overdue and has finally come. But I don't think we should lose sight of the tennis player who is able, for the first time ever, to be able to market himself as an IU athlete and give tennis lessons to kids and earn a little extra money. It's for the first time ever that a volleyball player can go back to her hometown and run a camp or a clinic, and in 3 hours make $5,000, which is meaningful money for a college student, and being able to profit off of their name, image, and likeness. And so I think when you look at the opportunities, but the holistic approach of the athletic department, I think we're in good shape NIL wise. And I can tell you, from revenue sports like men's, women's basketball and football, all the way down to not down, but to programs that historically would not see themselves as money-making enterprises. I'll just use some that I actually oversee as a sport administrator: swimming and diving and tennis. They are incorporating NIL pitches to prospective student athletes. They're telling them about those opportunities. I think at a lot of institutions, it's football and you're lucky to get anything else.
Yeah, so maybe Tyler can provide a little bit more insight now on collectives and how that features into what Jeremy was just talking about.
Yeah, so collectives were originally designed when NIL started to provide an infrastructure for student athletes to have opportunities. There's a little negative connotation with collectives, and for good reason at a lot of institutions. But they're originally designed to pool money together and create these opportunities for athletes at a given school. As I mentioned, there is a little bit of a negative connotation to collectives, whether it be inducing, talking to kids in the portal, those things that are strictly forbidden by the NCAA. Hoosiers for Good, which is an organization I run, didn't want to be associated with that at all. So I hate using the term collective for us. What we wanted to do is we wanted to provide an infrastructure for student athletes to get engaged in the community, allow them to use their NIL to really amplify important causes that are all near and dear to our heart in this state. We are one of the very few collectives that are broad-based in our actions, but also we've got a policy when we started Hoosiers for Good that made that an important component of what we do. There's not many collectives that are like that, and I'm really proud to say there's only one sport that we haven't signed a student athlete in yet, and we are working on it. So I don't think there's any men's tennis athletes in here, but we're going to get there. But we've provided some meaningful opportunities, and the student athletes have done some meaningful work so far, and it's just it's proud to see.
Yeah, thank you for that. And now, Jayma, would you like to spend some time talking about Title IX and how that gets into NILs and applies to issues?
Certainly. Thank you, Amelia.
Yeah.
And thank you for holding this panel. It's really great to educate everyone on this. So Title IX was a civil rights law that was passed in 1972 that prohibits sex discrimination in educational programs, an educational program that receives federal funding. And when it was passed, there was no discussion about it applying to sports, but sports is the area where it's been most active. And in fact, on the Hill in Congress, as soon as the word got out, oh my God, this may apply to sports, there was a massive movement to actually exclude sports from Title IX. There were 4 attempts to amend Title IX to exclude sports. When that failed, there were attempts to exclude the revenue-producing sports of football and men's basketball, and then that failed, and there were some compromises made after that. But the issue about Title IX that really is most troubling in the sports arena is that it's not enforced and it's not complied with sufficiently. I don't know, we had the 50th anniversary last year, and there were a lot of reports. USA Today especially did a comprehensive study about how many schools, both at the high school level and college level, don't comply with Title IX. So now the question is, we have NILs and collectives. And collectives, theoretically, are third parties independent of schools, right? So an independent entity that doesn't receive federal funding would not have to comply with Title IX. But so that raises a number of issues. Most collectives, unlike what Tyler just told us that transpires here, are heavily involved with men's sports. football players and men's basketball players. Most of the NIL money is going to men's football players and men's basketball players. Yes, women basketball players are doing well, and there's some individual women like Sydney, here, but people like Caitlin Clark and Livy Dunn, who's a gymnast, who are getting substantial money via NILs, but the number of deals and the amount of the deals in the aggregate are heavily weighed towards males. So that you have to ask, well, what is going on? Is that sort of violating the spirit of Title IX now that we have this third-party organization who's engaged in providing benefits to athletes that the school would not be able to do? If the school were providing directly the NIL monetization, then the school would fall under Title IX and have to provide equivalent numbers and dollar value to women athletes. So I think that's where we've come into a lot of problems over the last year or two. And compounded now on top of all that is that a lot of the collectives are fully intertwined with their schools. Not here, but at other schools, for instance, now the fundraising organizations at the school are providing NILs. The coaches are telling the collectives, we want that player, and here's how much you need to go out and find a minute for it. So boosters are involved via the collectives, and some of them individually, in recruiting and reducing athletes to come to their schools, either initially or via the transfer portal. So right now, I'm all for additional benefits to athletes. And in fact, I was telling Tyler and Jeremy, the sweater I have on now, some of its proceeds went to IU athletes. It's via the NIL rules that has permitted that, and I'm all for that. But again, we've got some bad actors out there who are getting a lot of the publicity, and we need to figure out how to rein them in. And I think we'll get into that again. And I think that goes back to Tyler when he says collectives have developed a bad name, because we do have these boosters. Before it was under the table, the money went. Now all of a sudden, through the NIL monetization, it's above the table, although we don't always know how much it is. But nonetheless, their boosters have gotten very involved again at some schools in recruiting athletes.
Yeah, I mean, going off of that, there have been a lot of issues in the past, and I know we're trying to implement a lot of changes. I know the NCAA is trying to get more involved, and there's supposed to be more federal governance on this soon. So getting into a bit of that with recent changes, where do you guys think we're going to go in the next couple of months, years with this, whether that's in regard to transfer portals, recruitments, retention, guidelines? This could be open to anyone that wants to discuss.
Well, a couple of things. One, I would say of the 350 or so Division I college athletic programs, 340 at least have a multimedia rights partner. Ours is called Learfield IMG. They are the biggest actor in this space. They sell the ads that are on our radio broadcast, the ads that you see on our video boards, the signage that you see as you walk around the concourses. Sometimes they have sponsorable digital social media content that we produce. I think a big change that is going to be happening and is already starting to happen is that, and I think this will get into areas of Jayma's, and our concern. But what I think is going to happen is that the Learfield IMGs of the world are going to be compelled to pay sponsorship deals to the student athletes, and that's going to become an arms race of who can get the most basketball players paid deals that end up on their video boards or on the radio network. So I think that is going to be something to pay attention to going forward. I would also say that the changes in the rules as it pertains to NIL is part of a long continuum of student athlete rights and student athletes recognizing maybe where there is a gap to be filled as it pertains to their rights. And I think there's going to be a continued push for revenue sharing for large television contracts that have led to some conference realignment of late, including in the Big Ten Conference. And I don't think it's just going to be the football players. I think women's basketball players are keenly aware that 10 million people watched the Final Four on ESPN, and that their actual media rights deals are criminally undervalued, and that they could charge more for that, and they could engage in revenue sharing. So I think revenue sharing is going to be something that is going to be debated, and then that will end up being in an argument on whether or not student athletes are in a separate category, or should they find themselves as employees, and it becomes an employee law situation. So I think those are some things on the horizon to pay attention to.
Yeah, I mean, I'd love to spend some time talking about federal legislation. I know Jim and I recorded a podcast yesterday, spent a lot of time talking about this, but I'd love to hear everyone's approach, whether you think there's a likelihood that we will get Congress to act and finally pass new law on this, or maybe even provide a little background on why we might need federal law.
So my brother-in-law did respond to my text, so we'll go from there, but I'll let you guys start.
Mind before we flip to the legislation part, I'm really troubled about the revenue sharing, and that is coming, unfortunately.
Mhm.
And there's an antitrust case right now in the Northern District of California called the House case. It was brought by the same set of attorneys who have chipped away at other amateurism rules that the NCAA had. And there's a real issue here as to how the revenues will be shared. Is it those athletes that produce the revenues that should get them? What happens then to the women? Does Title IX come into play here? Or is it a different law like Title VII and the Equal Pay Act, if they're considered employees, that would require equal amounts of revenue going to an equivalent number of men and women? And the other thing that I'm worried about, and I'd be curious to know where you come out on this too, is if the revenues are shared, fewer revenues for the athletic department, what happens? Do they have to cut sports? We really like the broad-based sports here, and most schools do. There's real value to that. But if there's less money in the athletic department, it's the Olympic sports, in particular the women's sports, that are going to be first to go. So before we go to legislation, I'd just be curious to,
Yeah, I think the challenge with Olympic sports is a bit of a misnomer. You tell the baseball coach it's an Olympic sport, and it's like, we're the national pastime, we're not an Olympic sport. But basically it means sports that do not generate more revenue than what they produce. And frankly, at Indiana, that's 21 of the 24 sports. I would also say that the Olympic movement in the United States in particular, and for a lot of countries around the world that send their athletes to the United States to be trained, is kind of built on this Olympic sports model, which I think is why that they're called Olympic sports. There is a finite number of resources. While the revenues are substantial, in coaches' salaries, especially in the revenue sports, have grown exponentially over my relatively short career in college athletics. There is a finite number of resources. And so the question is, where would you cut expenses? And it could be in student athlete services like academic advisors. It could be the people who work for me who make graphic design, and it could be me, frankly. But then also probably the easiest way to save money, but the most painful way to save money, would be in eliminating the number of sports offered. Indiana offers 24 sports. Ohio State offers 36 sports. Schools in the Southeastern Conference offer between 14 and 17 sports. They're not nearly as broad-based. I would argue that Olympic sports bring a lot to the campus community. People from all over the world, a variety of backgrounds, a lot of people who get the opportunity to be first generation college graduate. I do think it would provide a fundamental challenge to that. However, the argument could be, we're out here playing. 60 million of the $70 million in the TV contract comes from football. We deserve the money. And why do we have to carry the load for all the other sports? So you have these two competing interests kind of colliding over this issue, and it's going to be really difficult to figure out.
And you also have the coaches in the revenue producing sports who are making very fine salaries. And so I think the athletes look at that and say, all right, that coach is making $10 million a year and has an enormous buyout. Why should all the money be going to them and not being shared with us?
I would also say, Jayma, to that point, why the head coaches over time have been compensated pretty well, not to the outrageous sums that they've been compensated in recent years. But I think the most interesting thing for you to do is walk through the corridors of Simon Scott Assembly Hall or our football stadium and look at a picture of our basketball team in 1990, and then look at a picture of our basketball team now, and look at a picture of our football team in 1985, and look at a picture of our football team now. There are a lot more adults in those team pictures now than there were in 1985. They've got quality control analysts and recruiting coordinators and video people and people. I work with them. I don't know what they do. And there has been, and maybe similar to higher education overall, I think there's maybe, a feeling that there's been some unnecessary staff growth that has been able to occur because of rising revenues, that the athletes want a portion of that money. Sorry, I'm over talking.
No, that's great. Tyler, we want to hear about you and the collectives.
Well, I was going to chime in and, I think it's more likely that revenue sharing gets here before a bill in the NIL space is settled on. If you pay attention to Congress, they don't seem like they can agree on anything right now, let alone something that I think is very nuanced and more complex than I think people realize. When you factor in international students and visa implications, and if they're employees, then their scholarship get taxed, and all these different factors. And to Jayma's point, there's a lot of cases out there. House versus NCAA, I think, is going to be one that could really change. There's a couple NLRB complaints. All those things I think will come to fruition before an NIL bill, but I could be wrong.
Yeah, I think what will happen here is, let's back up for one moment. The NCAA rules prohibit revenue sharing right now. So the rules, the amateurism rules, and they've had these rules since NCAA was established in 1905, schools cannot pay the student athletes. The Alston case changed that a little bit, and now they can give them $6,000 or so in academic awards and $6,000 or so in athletic awards. But there's still that rule. So the NCAA would have to change that. And there was legislation in California over the last year or two that would permit the California schools to share revenues with their athletes. And that ended up dying because of the Title IX concerns. But California was also the first state that proposed an NIL bill, and it eventually occurred. So it's unclear to me how we're going to get there. If it's going to be the House antitrust case, state legislation, or federal legislation.
Yeah, I mean, I think we're starting to hear a little bit more on revenue sharing. Even after the most recent NIL hearing, Jack Swarber, who's the athletic director at Notre Dame, he even came up with this new concept that I think the schools will decide together before an NIL bill is decided. And part of that's revenue sharing. Again, you got to set up an infrastructure. You got to have somebody that's helping athletes and bargaining on their behalf. But yeah, in my opinion, I think that'll happen before an NIL bill. And then you have to figure out the Title IX thing. I mean, that's something that's very important. And
I would also say an important thing to consider in the argument for revenue sharing is the dynamics of the student populations that comprise the student athletes in the revenue sports to those in the Olympic sports. And I think it's an important dynamic, and it's something that's important to talk about, which is, and I don't want to generalize about large groups of people, but I think it's fair to say, if you look at the team photos of our two basketball programs and our football program in comparison to the other 21 sports, and you have a lot more students of color on those teams, and they're producing the revenue, there is an argument, wait a minute, we're producing the revenue and you're providing for the swim team. So there is a tension that is rising there that I think is going to be arguments that will be found compelling as the arguments go along.
I think also compelling is that at most schools, the athletic departments are not generating revenue to support the department. Like student fees and institutional and public subsidies are supporting the athletic department. So if we're going to engage in revenue sharing, I think you really have to think about, well, which schools will this apply to?
Well,
and then it's going to be more and more of the haves and have-nots.
And you make an excellent point in that this is an old statistic, and I think with the new television contracts, this has changed. But 7-year-old data, about 25 Division I athletic programs broke even or made money. The rest of the 350 lose money or have to be subsidized in some way. My guess is that's probably changed, but I still would say the number is skewed on the side of athletic departments losing money. Indiana's one of the 25 that we break even. We do our best to pay our bills. But then there's also the question. So there's revenue sharing, but does that include the cost of the scholarship? And the cost of the scholarship in Indiana would be roughly between $40,000 and $60,000, depending upon whether you're in state and out of state. Will that revenue sharing number be more than the $60,000 of the scholarship? Does the entire football team make a dead even share of that? Or is it like professional sports where Steph Curry makes more than Trace Jackson Davis on the Golden State Warriors? I don't know. These are very difficult things to untangle.
Yeah, I guess, there's a lot of issues going back to the very law student in me wanting to know about legislation, but how optimistic are you, Jeremy? I know we were talking about this beforehand. It's got a bit of an inside scoop on this stuff, but also Jayma and I guess we're talking about how optimistic are we that there will be some federal law that comes out and tries to address some of these issues. There's a lot of different proposed ones right now. They all cover varying topics, some completely dismissing some other important issues. Personally, I'm very interested in the whole international student athletes, and some of these bills don't even mention them in it still. So I'm just kind of curious in all of your take on how optimistic you are in the near future that we're going to be able to address some of these issues.
My brother-in-law is the United States Congressman who represents Cincinnati. And so I texted Jayma, asked the question. So I texted him and he said, 0% that we're going to get this done in the next session. But I think it's been a frustrating week at work for him. So I don't. So I think to Tyler's point, I think revenue sharing might be addressed before they find some sort of common ground on NIL, but I could be wrong.
I'm going to go out on a limb and disagree with both of you.
Okay.
I do think that NIL legislation will come to be before revenue sharing, because it has been debated so much now in the last few years, and there's heightened interest in getting that under control. And given what's going in Congress, as we know, we don't have a House Speaker, right? We've got wars there's so many important issues going on. But think about sports. There are also so many of our senators and representatives who are very fond of college sports. They either played it themselves, they coached it, or they just, that's their wonder drug in life is watching football games on Saturday, college football games. So I think that there is sufficient interest that there will be an NIL bill passed. It's a matter of how narrow or broad it will end up being. Some of the proposals are very specific, dealing with particularly the transfer portals, the inducements, and protections against unscrupulous agents. Some of them codify that issue of not giving employee status to the athletes. They vary a lot, but there are 8 bills pending right now in Congress. And you've got people like Ted Cruz, who's very involved. He's dropped a discussion draft that the NCAA actually highly supports. There were NIL hearings held by the Judiciary Committee, and he's a ranking member of the Judiciary Committee. And he has said that he thinks it's 60% likely that a bill will actually pass. And he's also a ranking member of the Commerce Committee, the other big committee that must come to terms and make some agreements on what would be a bill that would actually make it to the floor. So
It's not the first time my brother-in-law has disagreed with Ted Cruz, but yes. Yeah.
So, I mean, clearly, they're all very, very involved in other things, but, funny things slip through in bills.
They do.
So who knows, what will happen.
You guys know my stance. No, I think, how quickly revenue sharing will happen. I'm not sure. Again, there's got to be an infrastructure set up for that. But we're about to go into a presidential year. And I think there's a lot more important things that are happening that will probably take precedent over this. And again, I've been somewhat disheartened by some of these hearings because I don't think they really talked about the root issues of NIL. And maybe they're getting closer, but I just think they don't know enough right now to where I would feel comfortable with them even making a decision for where we're going. But
Well, I think you bring up a really good point. I mean, do we want either the courts or Congress deciding what's right for college athletics? It needs to be a more of a holistic analysis. So,
I mean, yeah, you mentioned root issues. So without making you draft a bill, like what things collectively do you think that you'd rather them put in? I mean, you see day in and day out, you're talking to athletes. What do you feel like, maybe just speak on IU's athletes, they come to you, what issues do you feel like you face the most often?
well, for me, I'd would like to be able to support international students, and not to be able, when in my previous role, like I mentioned, I was in compliance, and there was some discussion when I was there about on a completely separate bill, being able to slide an international student athlete NIL portion into there to be able to get that passed, and eventually that died because they thought it would take away support for a bigger NIL bill that they were advocating for, and it's been disheartening to see there's been no traction on that. You can be creative in some ways when they're on their home soil and their home country to be able to do some things, but how many of them actually go home that often for us to be able to make an impact on them?
what might be helpful is for you to explain the F1 visa and what the issue is here with international students.
Yeah, so when you're here on an F1 visa, it's a student visa, so you're really limited in your ability to work. And so the last thing we want to do is get somebody deported. So because of that, they're not really able to monetize their NIL when they're here. Again, there's some limited flexibility when they're back home and on their home soil and being able to do some things. But the F1 visa, we're talking about revenue sharing and employment status. What happens to international student athletes if this isn't corrected, right? Because then they're going to be, they're going to not be involved again. And again, I think that's a big component of something that we've got to address here soon.
I'll give you a shout out. Your brother-in-law's bipartisan bill is the only pending bill that I believe has fixed this problem, would fix this problem. So kudos.
He's a good guy. Yeah, I think that's a huge issue. And I say this as a sport administrator for swimming, and I just talked about how they're less diverse than other programs, but the best athlete at Indiana by far, and it's not even close, is a Tunisian swimmer named Ahmed Hafnaoui. He is the best swimmer in the world. He's the reigning gold medalist in the 400-meter freestyle. He holds 3 world records. And he's one of the few athletes on campus who can't make money off of his name, image, and likeness, and potentially would be worth hundreds of thousands of dollars being a Speedo athlete. And we've got to figure out a way to change that. And I also think the spirit of the rules, and there are very few rules in this world, are in the NIL world, are being abused by institutions that through their third parties are making false promises that they are not fulfilling. Athletes are promised $100,000 to go transfer to a school. Well, once they transfer there, it's almost like dealing with the mob in some way, in which they're like, well, you're already here. Here's $5,000. What are you going to do? Tell on me? And I think there are a series across the country of broken promises made by collectives and not honest actors in the space.
One of the worst ones that I've read about involved a football player from Florida State, where the collective promised a high school student promised him $13.8 million to come. He had to live in Gainesville because it was illegal under Florida state law to say that you have to come to the Florida State of Florida. It's Florida State, right? Or
It's Florida.
Florida, University of Florida. And the collective reneged on the first payment. So before he even actually had started at school. So he transferred, he transferred to then Arizona State University where his father had played football. But that was really one of the biggest red flags that, this stuff is going on that is not above board.
Yeah, I agree, and again, that goes back to why some of the collectives have a bad rap, and why that term does in general is because there's a lot of over promises or false promises because they're in this business, a lot of them, to do one thing, that's win football games, win basketball games. Where, like I said, we're a little different, and in fact, Jeremy probably knows this, but
we haven't been winning in football recently.
No, it's because Jim Harbaugh is stealing our signs and stuff. But the one thing I'm proud of, we're working on right now that probably not many people know of. It's very, very early stages. Is Indiana is one of the only states that doesn't have an NIL law. I shouldn't say one of the others. There's a handful, but a lot of states have NIL law, and whether that's because the NCAA is here or not. But we wanted to get something on the books that reflected at least IU's values. And in the draft, we're working with our legal counsel, and Cook's heavily involved in our organization. And one thing that I'm sure you'll appreciate is in our draft, we actually say collectives have to abide by Title IX laws. So we're hoping if this gains momentum, that will force other people's hands to start doing what we do. Because if we were set up just to provide opportunities for men's basketball players and football players, I'm not sure people would appreciate what we do as much as they do now.
And I would also say, and I think it's important to say, I think there's this feeling that there is a sentiment among certain people in the population that Title IX is somehow some sort of charity given to women. We're charging $10 a car for parking for women's basketball games. We're selling 11,000 season tickets. Their jerseys are for sale in our bookstore. We're selling out volleyball matches. City Parish has 150,000 Instagram followers. Mackenzie Holmes can't walk to class without getting stopped and asked about her team. They deserve to be compensated in this way, I guess. Not just because of their existence, but like they have earned the hard yards as well. They are important spectator sports.
And the other thing I was going to say on that, I mean, Yarden Garzone, who's on the women's basketball team, how meaningful would it be for us to be able to provide her support right now with what she's got going on? And we can't, but it can be difference making for her and her family right now with everything they're going through. So hopefully we can get something there.
Right. I mean, it's a moment right now for women's sports. There's no question about it, both in colleges and in the professionals. Nebraska volleyball team just filled their football stadium. 92,000 people attended the game. Iowa with Caitlin Clark, they just filled their football stadium with 52,000 people. But the question, you have to step back and say, why finally? Well, if we didn't have Title IX, I really don't think we would be having this moment now.
And I think people need to understand sports history. People have looked at the difference of the number of people who watch men's sports as it pertains to women's sports, but we're talking about 120-year head start. If you look at the early years of college athletics, they were small clubs that played baseball and football, and then homecoming game, people would come and tickets were free and all that kind of stuff. Men's sports as we knew it didn't really exist until about 1940, 1950, after they existed for 70 years. It takes a while to build an audience. And as Jayma said, the audience is there. I mean, the World Series is going to get about 10 million viewers. It's a big event. The NBA Finals got about 10 million viewers. The women's Final Four got 10 million viewers.
And was sold out months in advance.
Yeah, for sure.
I was there and it was incredible.
Yep.
Crazy fun. But and this year, hopefully we're going to be at that final too.
Yeah, I know Jayma and I spent about 30 minutes yesterday, probably closer to an hour, just naming off all these like really impressive college female athletes and just like discussing all their brand deals and all their fun NIL stuff they're doing. Like you mentioned Livy Dunn earlier. And yeah, so I guess I don't have much more questions for you. We can continue talking about, like, I would love to kind of backtrack, and we talked about like inducements, and it was kind of vaguely mentioned and how that could be an issue, and the whole UF Florida of them saying come here and then mentioning it being like a mob. Could you talk about that more? Not the mob part, but the, you know, because we have potential issues with inducements and boosters and how things still kind of are under the table.
I think we have to go back to the NCAA again. And prior to this Alston antitrust case being decided in 21, the NCAA was preparing guidelines and new rules with respect to NIL. They were about to change their rules and permit third-party monetization. And they had a comprehensive set of guidelines, so they call it guardrails, that would include a third-party administrator. There would be transparency with respect to the deals. So you could see, the deals would have to be reported, and you could see where the outliers were, and therefore, you know, at least a rebuttable presumption that it was an inducement as opposed to anything else. Now, these transparency provisions are in most of the proposed federal bills, including, again, brother-in-law's bill. He's got the best provisions, I think, with respect to transparency. But I think that would be very helpful. What are the requirements here at IU with respect to reporting deals to you, both deals before they come? I mean, how do you enforce it, right, too? But
so our student athletes are very good in the classroom. We got like a 92% graduation rate. They, you know, most of the teams have over a 3.0 team GPA. And I just say that to all lay the groundwork. They are collectively lousy at turning in their disclosure deals as it relates to their NIL arrangements. We ask them to do so, but understandably, I think students don't want to tell people how much money they're making. There's dynamics in the locker room that maybe they're sensitive to. There's maybe they just forget that they've been asked to do it, that maybe they've got enough on their plate by balancing their NIL obligations, their coursework, and their practice and training that they forget to do it. But we get about 20% of the student athletes turning in what their NIL deals are. We're working on it.
I can speak for my previous role, where at the beginning of the year, student athletes are required to fill out a set of forms. Some of them are NCAA forms that are required to be able to receive financial aid or pick up your first check or to even practice. And it was very, very hard to get them to do that then when threatening financial aid and practice. So when there's no teeth to turning in disclosure forms, I think it's going to be hard to get. Yeah.
So what's the solution? Do you think the NCAA should require it? Do you think a federal bill should require it? State law?
I feel like a federal bill would probably be the only way to do it. And then I think it has to be done. And I actually think this is true, that disclosure broad-based, if everybody's disclosing all things all at once, then you do expose the bad actors in the space that promise $100,000 but only paid $4. Now that's an uncomfortable thing, I think, to ask of people to disclose. I mean, I don't go to parties and tell people how much money I make, you know.
But we can FOIA it and find out.
It's done every July by the entire staff. Who got a raise? Yeah, I think it would have to be a federal law. I don't think the NCAA would have any chance of making that happen.
Go ahead.
Well, I was going to say on the inducement and tampering, you know, subject and the nuances NIL, and you know, I'm not a lawyer, so if it's an antitrust issue for them enforcing, you know, rules as it relates to NIL and limiting outside income potential, you know, I don't know any of that, but I do know the NCAA still has rules related to tampering and related to inducements. You know, if they can go to IU and say you gave a recruit a T-shirt on a visit and we're going to give you a level 2 penalty, why can't they do it in this same way? So maybe for all the lawyers in the room, you can help me with that, but.
But I think one particular area is the pricing. Well, first of all, you can de-identify the information, right? So their names are not disclosed. There are definitely some privacy issues that you'd want to protect. But I would like to see, like the NCAA now has a rule that boosters, if they employ, or it's not even boosters, any employment, outside employment, must be at a fair market value or a value commensurate with local rates. And I would like to see that with respect to NIL, so they need to be at fair market value. So and there are problems with determining what a fair market value is, because it's going to vary greatly depending on the school, the athlete, the division, all kinds of teams. But it can be done. It's done for the pros. But then there are antitrust problems with that, because, you're talking about price fixing, really. And so we need the federal government to order it.
So before we open this up to anyone else's questions, I want to give you guys the question that I'm often given whenever I tell anyone that I'm interested in NILs and sports law. And it's the most general, untechnical question. So I just want to hear your thoughts. But we always hear the argument of, by providing NILs to college athletes, we've forever changed sports for the worse. A lot of times people argue. So I want to hear your thoughts on that. If you think that, offering NILs generally has hurt sports, or in your opinions, bettered it.
It's fair. It's right. It's intellectually indefensible to talk about the old way. We are very close to the Jacobs School of Music. Somebody who plays the trumpet in the Jacobs School of Music, who's part of an IU official jazz ensemble, can't provide trumpet lessons to kids and say that they're a trumpet player in the Jacobs School of Music. It's ridiculous. Well, that's what they told athletes for 100 years. I would also make the argument that they said the exact same thing about the Olympic Games. Mary Lou Retton was on the cover of the Wheaties box right after the 1984 Olympics, but she was an amateur when she was doing flips there, and everybody cheered for her. No one cheered any harder for her than they did Simone Biles, who's a multimillionaire in the last Olympic Games. And people court rushed when we beat Purdue last year with a lot of fairly well-compensated basketball players. People were really excited when our women's basketball team beat Iowa, filled with well-compensated basketball players on both sides from the name, image, and likeness. And Mackenzie Holmes still loves being at IU. Devin Taylor, great baseball player, still loves being an Indiana Hoosier. Our fans love Devin Taylor. Our fans love Mackenzie Holmes. Our fans love Trace Jackson Davis. I don't think it's changed the dynamic at all in any negative way. And I think it's been totally positive. Yeah, people are cheating in NIL. They were cheating before NIL. And in reality, what has happened is that programs and athletic departments that didn't cheat have been able to even the playing field by having a legitimate, above board way of people finding people to support their student athletes. So I would say, other than the arguments that we're not doing as well at this as other schools that we have to take from coaches at work, I think it's been a totally positive thing. I've been a little robust on this. Feel free to disagree, but I think it's been a great thing for student athletes in athletic departments.
In general, viewing's up, I think. And so as I heard the sports, I don't know, probably not, since viewing's up. Is it created tension in the locker room? I don't know. I haven't heard of any, but I think overall it's a good experience for athletes. It allows them to get started earlier in life. A lot of student athletes are not making millions of dollars. What they're doing is they're using their NIL to help pay for school. There's how many sports can offer full rides? 6 sports. Everybody else is on a partial scholarship. So a lot of them are using their NIL money to help pay for school. And so in a lot of ways, it's very positive. And since Jeremy brought it up, 6 years to date almost, the SDNY came out and had a case against how many college basketball coaches for paying NBA minimums to come to their school. I think where people start to freak out and become disheartened or scared is when they can actually see it. But to pretend it's not happened for a long time is, I think, silly, because it has.
I mean, I think it's been great to accept that the bad actors have been really bad, and that we need to have regulations so that doesn't continue. The other thing I think I would point out is, well, two things. One, first of all, the NCAA made the mistake in its antitrust cases saying, hey, look, no one will want to watch college athletes if they're paid. And that goes to your point, which is totally wrong. And the same argument was made with respect to the Olympics in the 70s. And Congress came in, and there was a commission, a presidential commission appointed to study the issue of whether Olympians needed to be amateurs. And the rules were changed. And as you pointed out, now you can make a lot of money as an Olympian, and the popularity has not changed at all.
I think back to wonder what would have happened, where we would be if the NCAA never appealed the Alston case to the Supreme Court. That the Supreme Court made it clear, and that was tied to educational benefits, but it really caused the NCAA to pause and scrap their whole proposal related to NIL. Had they not appealed that, there's an argument that they would have those proposals, in place. And, it's kind of silly thinking back that they are appealing a case to the Supreme Court, a case that's tied to education, when that's what we're supposed to be about. But
right. So in that case, the court unanimously 9-0 held that the NCAA's limits on educationally related benefits was illegal, but it left open, because it wasn't appealed, the question of whether compensation that's not educationally related, limits on that are illegal. That's the next case. That's the House case that's pending right now in Northern District of California. And it'll be really interesting to see where that goes. But to preview it, Justice Kavanaugh, in a concurring opinion, was absolutely blistering with respect to his criticisms of the NCAA and its artificial distinctions here. Said, the NCAA is operated like other businesses in the country. It's a monopoly, and the schools have agreed to pay the laborers zero. And the NCAA is not above the law. So you can imagine, if this next case goes up to the Supreme Court, I'm expecting Kavanaugh will write the majority opinion, and we might have a completely different decision. But that's going to be years away.
Yeah. Before we offer, if anyone has questions, to come answer, I want the IP clinic to be able to come up. Professor Hedges is going to tell you a little bit about what they offer, their NIL services, and a little shout out for anyone on Zoom that's an IU athlete, so they can have somewhere to come and help out.
Absolutely. Thank you for the opportunity. I'm the director of the Intellectual Property Legal Clinic here at the law school. We handle all forms of IP, including right of publicity, which the name, image, and likeness falls underneath that. And one of the opportunities we have for our clients, all students here at the university, not just student athletes, have an opportunity to come and get representation on whether it's the agreements they're looking at, maybe it's even the agents' agreements that they're looking at as well. And so we provide that opportunity for those students to come to us, talk to us. We've got NIL expertise there in the clinic to give them that advice, so they're not entering into perpetual contracts that have, long-lasting negative impacts on them, so that they know what they're getting into, to watch out for themselves on that. And also gives our students here at the law school an awesome opportunity to start cutting their teeth in the practice of law and getting some exposure to this very exciting area of law. But again, it's under my supervision and some other people that have expertise in this area. So thank you, Amelia.
Thank you for that. So if anyone has any questions, now is time to ask, or we can keep talking for like another 10 minutes or so, but I want to make sure that any other questions are addressed. Yeah.
Okay, so Tyler and Mary, I think this one's for you guys.
Okay.
Indiana's approach to preventing bad actors from interfering with NIL deals is unique and certainly ever. Outside assistance from the IP clinic, we heard about, would you explain the strategies or methods employed by Indiana and Hoosiers Connect to maintain the integrity of these deals and safeguard student athletes?
So a couple of things, and I promise I am not doing fan service to law students here, but One of the things that I think is really important is that our collectives have a lawyer on retainer who actually, inspects every aspect of how the collectives operate. The other thing that we do, and I think a lot of institutions, not now, but in the early stages for sure, Blanchett, we actually openly encourage them to find legal representation. Find an agent. Make sure you have somebody knowledgeable in this space who's advocating on your behalf. And those who tend to have legal representation and agents tend to make those that owe them money have to follow through on whatever they said they were going to pay. So we really encourage our student athletes, whether it's through the law school here or those that maybe at a higher level that can afford representation, to have an agent argue on their behalf to make sure that they're getting what they deserve and what they're worth.
Yeah, outside of everything he mentioned, we're another support system for them. They've a lot of athletes have come to trust us and bring opportunities to us and talk about how should I negotiate? What should I look for in an agreement? Am I giving more than what I should be? And not in line with what I should be paid, So we help them talk through a lot of those things. But we really encourage them to look at their Hoosiers Connect agreement that really outlines all the big parameters and make sure you've got a lot of those safeguards that we have in ours in yours to safeguard against NCAA issues and things of that nature.
I have a question from online. How important is it for college athletes to have NIL deals when going forward in their careers? Are international students put at any kind of disadvantage when going professional when compared to their peers who do have NIL deals?
And I think it's important for us to continue to tie college sports to the educational model, and it's important for us to do whatever we can to prepare our student athletes for the professional and quote real world. And that is everything from protecting their and supporting their free speech, as painful as it might be in the last couple of weeks, to preparing them to be able to handle their finances and build their brand for their time when they get out of school. I do think some of those that might have NIL deals in college on the brand building and handling business might interface those questions earlier than our international students. But one thing that's been interesting is that the international students are keenly aware of NIL deals and want to learn more about NIL. So in a weird way, their predicament is leading them to become pretty educated on these topics.
I don't think I can add anything to that.
I think I saw one more hand. Yeah, Jake.
You discussed
anytime I think of federal legislation, I never want to limit a student athlete's opportunities. I want to do everything we can to protect them, which includes trying to weed out the bad actors. This model, college athletics, for a very long time has had bad actors in it. You're not going to get everybody, but as much as we can at the federal level to have teeth to protect athletes. And I don't know exactly what that is and what that mechanism is to do that. But starting out with anybody who's going to enter into an NIL agreement with an athlete, whether it's a certification process that you got to go through or you got to disclose, so we can start having some information on who's entering these agreements. But again, I never want to limit an athlete's opportunities. I just want to make sure they're protected.
I think one thing that we haven't discussed is that the NCAA does not have subpoena power. So it has a really tough time proving what the bad actors have done. and that we've seen that most recently, Kansas and other universities. But many of these bills give either the FTC or a newly created federally chartered institution the subpoena power to actually go after bad actors and investigate them and then penalize them.
Can I just follow up on that, Jayma? That's one thing that I was wondering about with legislative proposals. I noticed they were wildly different in this regard. Some of them seemed like they were voting to give power back to the NCAA. Some of them were talking about creating this sort of a new board that looked to me like it would be largely controlled by the major sports conferences, maybe possibly the FTC. So, my question would be like, who do you think is going to end up with the real regulatory power here? Who do you think should end?
Probably the FTC is the best organization. And by the way, just full disclosure, I worked there for a couple of years after law school. And they are charged right now with jurisdiction over SPARTA, which is the federal bill that deals with unscrupulous agents. Now, the problem is they have never investigated an agent or found an agent to be in violation of the act. So if Congress would give the FTC the money, create an office there that would specialize in college sports and the NILs, and I'm sure there'll be other issues, then I think that's a good option. It's a big if, Yeah.
This is more of a practical question, but I assume that with NIL opportunities for student athletes coming about, that would result in money shifting away from contributions being made to athletic departments to the student athletes. And has that come to fruition, or have the contributions still coming? Doesn't have to be specific, but by and large, have those donations continue to go in, or has that money kind of shifted over to the collectives or the individual student athletes, and has kind of the facilities arms race kind of slowed down, heated up, or any general observations on that?
It's a great question, and I know that I'm representing an athletic department that's got a fan base that's upset that we don't have better facilities in football, and but I would say it was a eureka moment. Mark Cuban was touring our new basketball locker room. And he's like, "This is unbelievable." We're like, "You own the Dallas Mavericks." And he's like, "There's no way this is as nice as the Mavericks locker room." He's like, "Yeah, it is. We pay the players. They don't care what the locker room looks like." And I do think in the pre-COVID and pre-NIL era, if you watch D1 Ticker or Sports Business, it was constantly Clemson had a barber shop in their locker room. There's a water slide at Alabama. The foosball tables at Oregon, the soccer players are wearing Nikes, like the whole thing, like the entire wall is made out of footballs. There was this facilities arms race, and facilities are still really, really important. I do think the emphasis of the donor class that's wanting to support athletic departments has made its way to NIL. Large scale fundraising for the athletic department, this is a bit of a misnomer. I think people think like you raise money to build things, and that is true to a certain extent, but usually there's like a massive lead donor on that, and then you fill in the gaps with other people. The lead donors are the ones whose names are on the building, so there you go. The bulk of the fundraising is for the scholarship program to pay the scholarship bills that the athletic department owes the university. When somebody says it's a full ride, they don't go to college for free. The student athlete doesn't have to pay, but somebody has to pay the university for that student to go to college. And so the fundraising and development arms of the athletic department are raising money for the scholarship fund. That is held stable. I think people still see the value in donating to that to provide opportunities to our 700 student athletes. I do think raising money for a massive facility project in the NIL times would be more difficult. I think that's where the rub would come. That's the Indiana experience anyway.
Maybe A secondary question there is the nonprofit status of certain collectives. If you give a donation to the athletic department, the booster gets tax deduction. So tell us about the nonprofit status of collectives and the IRS.
Yes.
IRS.
It's a lot. So we were one of the first collectives to file 1023 application and receive 501c3 status. We filed last March, so March 2022. 35 days it was approved. So maybe we just hit it at the right time. I don't know.
And who filed that, by the way?
Fred did. So
Proud graduate
yeah,
of the law program here.
And so fast forward to this summer, early June, the IRS issued a memo related to I think more just legal guidance related to nonprofit collectives. And there were a lot of concerns that, they're really set up for a private benefit as opposed to a public benefit. Listed out some examples of why they thought that. And it really made us pause, right? Like we're here to help provide opportunities to student athletes, help support IU, help do all these great things in the community, but we don't want to risk jeopardizing anything, right? And the guidance we received was it was not a binding memo. It was just some guidance at that time, and at some point they will come out with binding guidance, and we're going to have to change. I don't know if that's next week, next year, never. I don't know. What's really interesting about it is 3 months after they issue that memo, they approved Michigan's 501c3 application for their collective. Sorry, I don't have an answer. It's not real clear on what we do know is we don't want to risk jeopardizing anybody. We're staying true to exactly what we said we were going to do in our application, and haven't wavered from it. Now, could the IRS issue or memo be targeting another collective who's facilitating car deals? Maybe that's what it's for. I don't know. But we're staying true to what we said we were going to do, and we'll continue to do that until we're told otherwise, and go move in a different direction.
And because there's no transparency, there's no data, so we don't know how much money's being filtered through the nonprofit collectives that would otherwise be going to the athletic department.
As it relates to NIL and that point, there's certainly a lack of transparency in this NIL environment. It's very true. It just so happens the most transparent organizations happen to be the nonprofits, because we have to be transparent, right? We have an annual report, talks about how much money we've raised. We have all our Schedule B information on who's given us money that goes to the IRS. We have all of our contractors that were hired to retain their rights to make that impact on these charities. All that information's in there. So it's just funny, there's no transparency, but the organizations that get the most scrutiny are the ones that are most transparent. So.
Seems to be kind of the common theme of NIL, like a lot of issues that still remain unanswered, but we're optimistic. Well, I guess some of us are more optimistic than others that we'll get some rules in the near future. I don't think there's any other questions unless anyone else has any, or any last remarks on behalf of the panelists. No.
One thing I want to say, and this is, I think you guys feel, or maybe are gathering that I'm pretty progressive on this topic, and embracing both the present and the future of all of this. But I'll be an old head about one thing, and that is, I think it is important, if there is still sports being run scholastically, that students are taking full course loads and making meaningful progress toward their degree while they are here. Whether their employees are getting paid, whether there's revenue sharing, all of this might change. But if you're at Indiana University, it is our obligation to not just use these student athletes for what they do on the field of play for a very short period of time. And even if they go pro before graduating, they have accrued enough credits that it's reasonable that they could come back and complete their degree. I think divorcing it from the educational model would be kind of that mistake. And then they become the Indianapolis Indians or the Fort Wayne Mad Ants, and people will care about it less. I firmly believe that. And I also think it's a betrayal of what we do. Yeah. I like the Indianapolis Indians games. The hot dogs are great, but like, I don't care who wins or loses those games. People are vested in it because they're students at their school. And I think it's important to graduate people.
Yeah, I'll say one short thing on that is, we're the only country in the world that has a model like this. And I truly believe it's something worth preserving. People love it.
Yeah. Well, thank you. Can we all thank them? And I wanted to
Thank you. Yeah, thank you.
and then thank everyone here today that came out, and then also thank you everyone that's zoomed in. I hope everyone enjoyed and got a lot from Mrs. I know I did. So